Welcome to part 3 of our video lecture series going over the different branches of government, on both the federal level and then in the state of Illinois. So today, we will be covering the Federal Judicial Branch. I'll share my screen real quick and we'll get started. So we've already gone over the legislative branch and the executive branch. The final branch in our federal government is the judicial branch. Where does the judicial branch get their power? This would be Article 3 of the United States Constitution. Ironically, Article 3 also gives Congress a lot of authority over the judicial branch. This includes the power to form inferior courts to the Supreme Court. Article 3 sets up the Supreme Court, but Congress has the power to set up the lower courts. This would be the United States District Courts and then the 13 appeals courts. Also, the number of Supreme Court justices is not a set number, so this can be changed. It has changed over the course of our country's history. We currently have 9 now. So we talked earlier, the legislative branch creates law, the executive branch enforces law, the judicial branch interprets law. They take law that has been made by Congress and enforced by the president, and they make sure that it doesn't violate the Constitution, that it follows what the founding fathers set out in the Constitution and its amendments. So the judicial branch of the executive government, there's 3 levels to it. I feel like everyone probably knows about the Supreme Court, especially with all of the news surrounding them recently. But the lowest level of the federal branch is the United States District Courts. There's 94 of them in total, at least 1 per state. So essentially, when a federal case starts, it would start in the United States District Courts. Then after that, if it's appealed, it would go up to one of the 13 circuit courts. And then after that, the highest federal court, the highest court in all of the country is the United States Supreme Court, or SCOTUS is what it's commonly referred to as. So what's the judicial process look like? Like I said, we would start out in the United States District Courts, the lowest federal courts. There's 94 of them. They hear cases regarding federal questions, so federal law, because states can make up their own law as well. But if somebody has a case regarding federal law, they would bring it to a federal court. That's what federal court's jurisdiction resides over. They also can hear cases over that have diversity jurisdiction. Diversity jurisdiction just means that the plaintiff or the person filing suit is from a different state than the defendant, the person that they're filing the suit against. So in the district courts, cases would be heard by a district court judge. In some cases, they could also be heard in front of a judge and jury if the parties so decide to use a jury, because in some criminal cases, for example, defendants always have the right to a jury. In Illinois, like I said, we have 3 different district courts. I'm personally from the Chicagoland area, so we're in the Northern District, and then there's also a Central and Southern District Court. So then, after the United States District Courts, there are the appellate courts. These are appeal courts. So if there is some sort of appeal process going on, say there was a conviction in a district court case, but the defendant felt that the judge unconstitutionally let in some evidence that wrongfully led to the defendant's conviction, they could appeal it to their appeals court, their circuit court. You can kind of see on this map where the circuit courts are broken up. In Illinois, we're in the 7th circuit of 13. It's Illinois, Indiana, and Wisconsin. So all federal cases that are being appealed out of district courts in this area would go to the 7th Circuit Court. These cases are heard a little bit differently, though. I find this interesting. They're heard in front of a panel of 3 judges. So you get a majority opinion by getting 2 out of the 3 judges to agree with your argument. Okay, and then the highest court is the Supreme Court. Here's a quote from Article 3, Section 2 of the United States Constitution. The judicial power shall extend to all cases in law and equity arising under this Constitution, the laws of the United States, the treaties made or which shall be made under this authority. So this is what gives the Supreme Court their power. They hear cases on appeals from the circuit courts. So if, like I said, a case is appealed from the district court to the circuit courts, and then it's appealed again, it would go to the Supreme Court. However, just because a case is appealed doesn't mean it's going to be heard. They can also hear any case, though, that meets the justiciability doctrine, which means that it can skip courts if someone petitions the Supreme Court and they find the petition enticing, say that it's a hot topic and they think an opinion needs to be put out on it, they can take it without it having to go through the full process of the district court, the circuit court. So what is the justiciability doctrine? Well, the person petitioning needs to have standing. What is standing? This means that they suffered an actual injury. And this injury was caused by the person they're filing against. So they need to show that they suffered injury, causation, that it was caused by the person they're filing against, and that the relief that they're requesting would address the injury they suffered. There also needs to be ripeness, which means that there's sufficiently adverse parties on both sides. It's not just somebody saying I was wronged, but I don't know who wronged me. They need to have somebody who wronged them, or a larger party, a larger entity, a company, an organization of sorts, even a state. That's why you hear a lot of times like so and so versus the state of. You can say that the state wronged you. The case needs to not be moot, which would mean that the issue hasn't resolved itself. You see this from time to time regarding college admission cases, people saying that for a long time, the court wouldn't hear college admission cases regarding diversity, using diversity within their admissions process, because they would say that once the admissions process was over, it was moot. However, they did decide that because admissions processes typically have fees, that the issue was not moot because the person was out $50. So that's how those cases ended up being heard on the federal level. The case can also not be a political question. Political question just means that it would be better addressed by the other branches of government. Is it a question of wanting to make a new law? Well, then it should be the legislative branch that hears that. Maybe you need to get someone to draft a bill, as we discussed in our first video. And finally, it can't be an advisory opinion. This basically just means that you're not just asking a question of constitutionality, like, oh, can the state do this? Like if there's a new law coming out, can they make this law? Is it constitutional? Well, unless someone suffers at the hands of that law, they don't have standing, and therefore it's just an advisory opinion. So it needs to actually impact someone before it meets all the requirements of the justiciability doctrine. Okay, so here is a little clip from a popular TV show that came out a couple years ago, How to Get Away with Murder, where one of the characters, the main character, actually argues in front of the Supreme Court. So we're just going to get a little inside scoop of how an argument would be heard in the Supreme Court.
As an arbiter of the law with whole knowledge of historical jurisprudence in this country, race must always be considered a variable.
You have precious time, Miss Keating. I suggest that you don't waste it by making arguments you've already made.
These are not my words, Justice Strickland. They're yours. You wrote them in your 1985 ruling in Bryant v. Topeka, an equal protection case dealing with a state housing lottery program. Racism is built into the DNA of America. And as long as we turn a blind eye to the pain of those suffering under its oppression, we will never escape those origins. The only safeguard people of color have is the right to a defense, and we won't even give them that. Which means that the promise of civil rights has never been fulfilled. Due to the failure of our justice system, our public defense system in particular, Jim Crow is alive and kicking. Laws that made it illegal for Blacks and whites to be buried in the same cemetery. They categorize people into quadroons and octoroons. They punish a Black person for seeking medical attention in a white hospital. Some may claim that slavery has ended, but tell that to the inmates who are kept in cages and told that they don't have any rights at all. People like my client, Nathaniel Leahy, and millions of people like him who are relegated to a subclass of human existence in our prisons. There is no alternative to justice in this case. There is no other option. To decide against my plaintiff is to choose lining the pockets of prison owners over providing basic defense for the people who live in them. And is that the America that this court really wants to live in? Where money is more important than humanity? Where criminality is confused with mental health? The Sixth Amendment was ratified in 1791. It's been 226 years since then. Let's finally guarantee its rights to all of our citizens.
So what we just watched there was part of her argument in front of the Supreme Court. As you saw at the beginning, one of the judges interrupted her during her speech, which is how those go. You present your argument, and if the judge feels that something you're saying needs to be clarified, they'll ask questions in the middle of your argument. There, in particular, she was arguing that the person she was representing, the named client of her case, but there was actually a whole subgroup of people, their Sixth Amendment right was violated because they did not receive adequate counsel and adequate attorney by the city, because the county was supposed to provide them a public defender, and they did not receive an adequate one because the county was understaffed and therefore couldn't adequately cover their case. So currently, like I said earlier, we have 9 members of the Supreme Court. There is no set number in the Constitution. That does change from time to time. But it is important to note that once you're appointed to the Supreme Court, you will serve for life. This is unless the justice decides that they want to retire, or if they're impeached, which is not likely to happen. I mean, we've seen a couple presidents be impeached, but they're not typically, no one's been removed from office. So our current Supreme Court justices, we have Clarence Thomas. He's 75 years old, and he was appointed to the Supreme Court in 1991. Justice Ketanji Brown Jackson, she's 53. She was the most recently appointed judge by President Joe Biden. Justice Roberts was appointed by George W. Bush in 2005. Samuel Alito was also appointed by George W. Bush in 2006. Sotomayor, Justice Sotomayor was appointed in 2009. Kagan was 2010. Gorsuch was 2017. Kavanaugh was 2018. And Amy Coney Barrett was appointed by Donald Trump in 2020. The reason I'm highlighting this is I want to kind of show you how long Supreme Court justices can serve. Clarence Thomas was appointed in 1991. He's been on the court for over 30 years at this point. And these people, they're the highest court in the land. And while they have a lot of power, and this power is supposed to be used in a responsible way, which I think we all hope that's what the Supreme Court does, I think it's also important to remember that these people do have a lot of power over our country. And that's why we get into our final slide, why your vote matters. These are people that have a lot of say in how our country is run, and they're appointed by the presidents that we elect. We're not actually voting these people in, they're appointed, but they're appointed by people we elect. And then they serve for decades. And I feel like people, when they think about the Supreme Court, they think about Brown versus Brown versus the Board of Education, which was in the 1950s, which desegregated schools. 1950s. So that's, that was 70 years ago, but we still have cases that are being heard that are landmark cases. Obergefell v. Hodges happened less than 10 years ago. And this legalized gay marriage nationwide, which essentially meant that no states could deny same-sex couples marriage licenses. This was less than 10 years ago. Like, this is important stuff that is still happening. I think everyone knows a little bit about Dobbs v. Jackson, which overturned the decision in Roe v. Wade, which legalized the right to an abortion, which happened. So the Dobbs case happened almost 50 years after Roe v. Wade. So this gave the states the right to decide whether or not they would allow abortions. Dobbs did. Roe v. Wade legalized it. Dobbs overturned it. So these are landmark cases, and these justices are appointed by people that we elect. So whichever way you feel about these issues, the people you elect appoint these justices, which make these decisions, which do impact our lives as Americans. And that's why your voice and your vote matters. That's all I have for this particular lecture. Thank you for listening. Next time, we're going to start talking about state governments, which I hope we get excited about, because I feel like we're not taught a lot about our state governments.